Morning, Attorney.
Good
morning, everyone.
Morning.
I think we're ready to start, Mr. Wright.
Yes, Commissioner. If I could just, for the purpose of this transcript, just record the names of the legal representatives present today.
Yes, thank you.
The Attorney General is actually appearing as a witness today, but she is supported by Sir Geoffrey Cox QC and Lauren Peaty of Withers, and also the Solicitor General, Ms. Joanne Williams-Roberts.
Yes.
No other participants have instructed their legal representatives to appear this morning. Commissioner, as you have indicated, the Commission is progressing by way of considering a series of topics. One of those was issues arising out of the position statements. You had invited participants and a number of other relevant actors to submit position statements to you on specific questions relating to governance and also the systems concerning law enforcement and justice. Those have been submitted. They have been published and were published yesterday on the Commission's website. The plan was to call a number of individuals to give further evidence to you from their particular perspectives on the position statements. It's not to put the position statements in or go through the position statements in detail, but to ask ancillary questions. As you explained, for reasons that you gave, we have had to put back the evidence of the Governor and the Premier, which means that we won't complete this topic in one go. But what we are attempting to do in the next couple of days is to call other relevant witnesses. And the first of those is the learned Attorney General, Dawn J. Smith. And if I could begin my question of the Attorney.
Yes, and the Attorney's already been sworn in a previous hearing, so there's no need to do that. Good, thank you.
Thank you. Attorney, you should have in front of you, you probably brought it along anyway, your own position statement that you submitted, but it should be in a folder there with you. Do you have that?
Yes, I do.
And that, as I indicated just a moment ago, has been published. And so what I'd like to do is not to ask you to read it out or to go through it paragraph by paragraph. It's there not only for the Commissioner to read, but for everyone else, but to ask you some additional questions, please. My questions are going to focus on two aspects of your role as Attorney General. The first is your constitutional position as the principal legal advisor to government. And the second is the perhaps more mundane but equally important role as the person who heads a department. So if I can begin with the first, when you last came to give evidence to the Commissioner, you explained there that you are appointed under, or an attorney is appointed under Section 58 of the Virgin Islands Constitution Order of 2007. And that follows, as you explained, a competitive recruitment process, which leads to the successful applicant being appointed, but upon the advice of the Judicial and Legal Services Commission. Is that a correct summary of the position? And what your role as attorney is not dependent on is the election cycle. Is that right?
That's right.
And so you could, for as long as you wish to continue as attorney, be the advisor to a government where there are different political parties forming government.
Provided I do not misbehave or become unable, yes.
The Constitution gives you a number of roles, and if you want to, you should have a copy of the Constitution on the desk in front of you if you need to refer to it. But I'd like just to set out those roles, hopefully in the order in which they appear in the Constitution. But the first one is that under Section 44 of the Constitution, the Attorney General sits on the advisory committee on the prerogative of mercy.
Yes.
The second is section 47, which makes you an ex officio member of the cabinet.
Yes.
And under section 47(6), that specifies that the Attorney General should not be entitled to vote in the cabinet.
Yes.
Section 57 makes you an ex officio member of the National Security Council. And does it also follow that you're not, you don't have a vote on the National Security Council either?
I do.
You do on the national, I see. So the reason I asked was that we've taken evidence from a former police commissioner who explained that he attended the NSC but did not vote. So you're in a different position from him.
Yes, I am, apparently.
And then, of course, we go to section 58, which appoints or mandates that there will be an Attorney General of the Virgin Islands, and describes the Attorney General as, and I quote, the principal legal advisor to the government of the Virgin Islands. And finally, under section 63, you are a non-voting ex officio member of the House of Assembly.
Yes.
Now, other than those roles that I have outlined, does the Constitution provide any other roles for an Attorney General?
I don't believe so, no.
If we take perhaps the key roles in turn, because you stand, I think I put this to you on the last occasion, but you're sort of at the center of I suppose a triangle, where at one point you've got the cabinet, another point you've got the House of Assembly, and the third point is the governor. If we take the cabinet first, what limitations are placed under the Constitution and laws of the BVI on an Attorney General sitting in cabinet?
Under the Constitution?
And any other applicable law, are there any limitations on what you can and cannot do?
Well, you can't vote. I don't know that there are other limitations placed by the Constitution, but you don't vote.
Are you bound by collective cabinet responsibility?
I believe so.
But do you consider, even though you are not, you're prevented from voting by the Constitution, that an Attorney General has a right to comment on all matters of policy that come before cabinet?
The Attorney General would limit herself not to commenting on policy, but to the legal implications of policies that may come before cabinet. That is the way I understand my role.
And so, continuing with that theme, you would not take your role to include, your role within cabinet to include the fashioning of policy?
What do you mean by the fashioning of policy?
That if the government of the day brings a particular policy for a vote before cabinet, then there may be discussions. There will then be a decision, which is a collective decision that everybody signs up to. Mm-hmm. But the route to that may involve different points of view being expressed. I'll come back to your role as the legal advisor to cabinet. But putting that to one side, do you think that it would be appropriate during those deliberations for an Attorney General to shape the discussion so that the decision is made in a particular way?
No.
Can I just go back to one question, one answer, Attorney? Because I got your answer down right, I think. I just want to make sure it's right. You were asked whether you considered you were bound by collective cabinet responsibility, and you said yes. Mm-hmm. Now, I understand that you may be bound by
I may have misheard you. I'm thinking confidentiality.
No, exactly, which is the reverse side of the same coin.
Yes,
I understand that.
Yes.
And I understand that you're bound by that, but you don't vote, So you're not responsible in that sense, but you're bound by confidentiality. That's what you mean.
Yes, that's my understanding. I mean, certainly when it comes to providing advice, the Attorney General is always available to provide advice. But in my mind, a bulk of that policy work has to take place before you get to cabinet, where you would have public officers putting the policy together, doing the research, doing the consultation, consulting with the Attorney General's office as the legal implications of what they're putting together. And to my mind, before something comes to cabinet, a considerable amount of work really ought to have been done in terms of fashioning the policy to ensure that it is sound.
Yes, thank you.
Right, and that the options are properly presented to the ministers before they make a decision. Yes.
And the effectiveness of the Attorney General's chambers in delivering that aspect of its work is something I'd like to come back to, if I may. But when you say ensuring that the policy is sound, from the perspective of yourself as Attorney General and your chambers, does it come to ensuring that the policy is legally sound?
It is legally sound, strictly speaking, and that it cannot be challenged in terms of how it came into being.
And so would a fair summary of how you see your role in cabinet to be that you're there to give legal advice, and you are there to ensure that the decisions that are made are lawful?
And made in a lawful way, yes.
Made in a lawful way.
Yes.
That's a better way of saying it, because I suppose any decision is capable of an attempted challenge. So it's, your advice is to ensure that they act as, within your judgment in a lawful way.
Yes.
Now, one of the points that you've made, and this is about, it's going back to the second aspect of what I'd like to ask you about, but the idea that the Attorney General chambers has clients, that
Yes.
concept. Now, for you as the attorney sitting in cabinet, who is your client then?
Who is my client then? Well, I'm advising the ministers when I'm in cabinet. So they're the clients at that point in time. It's interesting you use the term clients, because I don't know that because I use the term, and I don't know that people typically in the government would use the word clients. Because I have one client, and that is the government, right? However, the government is constituted in its different facets, it's made up of different people. So when I'm in cabinet, I'm advising the ministers. My client is always the government. When I relate to individual persons in the public service, individual public officers who come to the chambers for advice, we may refer to them as clients in terms of how we deliver the service to them, but I have only one client, and that is the government.
The other element of your role is as a member of the House of Assembly. In relation to the House, what role does the Attorney General of the Virgin Islands play?
What do you mean, what role?
Well, you're a member of the House. You can't vote.
An ex officio member.
Yes, and you can't vote.
Yes.
So I suppose why do you need to be there?
That's a question many people have asked before.
But does your role, for example, extend to advising on issues of parliamentary privilege.
Right, so I do advise the House of Assembly on matters in the House of Assembly on privilege and so on, yes.
And can you give the Commissioner any other examples of to show the sort of ambit of the role that you have to play in relation to the members of the House of Assembly?
So like any other aspect of the client, the House of Assembly might have, you know, numerous issues that come up relating to how the work of assembly is carried out from an administrative point of view. They may have questions as to parliamentary matters, what they can do, what they can't do, and how they can do it. Another role that I play in the House of Assembly is to bring bills and propose bills that fall under the areas that would typically, you know, be allocated to the Attorney General, such as the administration of justice. And that's principally what happens there.
Are you called upon to advise the House of Assembly as to the meaning and effect of legislation?
From time to time, yes.
So if, for example, an issue arises under the Constitution, is that something that the attorney would be asked to give advice to the House about?
Yes.
Now, you've said that your one client, one steps back from it, is the government of the Virgin Islands. When you're speaking of the government, are you also including in that the House of Assembly?
Yes, the government is the government is the government, yes.
But of course, the House of Assembly has an opposition.
It does.
How does the attorney's role then play out?
In the same way, I think in practice, the opposition is uncomfortable about approaching the Attorney General because they feel that they are the opposition. But if the leader of the opposition or another member of the opposition has an issue in the course of executing their responsibilities as a member of the House of Assembly, the Attorney General is someone that they can call.
You've mentioned that you will also take through the House legislation that falls fairly within the role of the Attorney General. And that is, can that be fairly described as a role that involves progressing the policy agenda of the government of the day?
What do you mean by the policy agenda of the government of the day?
Well, if the government of the day wishes to bring in, I'm going to try and formulate in my head as we speak a hypothetical, but let's say it wishes to bring in legislation that decriminalizes a particular behavior. And that is said to fall with that the attorney is the best person to pilot that through the House of Assembly. Now, others may disagree with that policy, and it is, and in my scenario, it's the proposal of the government of the day that this be done and this become law. It's a perception question. As the attorney charged with, if the attorney is charged with taking that piece, such legislation through the House, can they not be said then to be progressing the policy agenda of the government of the day?
If they were charged, but in practice, it really depends. For example, recently I would have dealt with an amendment to the Eastern Caribbean Supreme Court Act, which had to do with injunctions. It doesn't really fall under a ministerial portfolio. It doesn't really fit into a policy agenda, but it is something the Attorney General can support. And I was responsible for that, and I took that through. There are other amendments that I would deal with, for example, where it has to do with amending criminal justice legislation. We have recent examples. We had For example, the Attorney General leads the BVI delegation for the Caribbean Financial Action Task Force. And there was legislation that was to be amended in order to meet our obligations as we saw them. And I was responsible for taking that through. Equally, you may have had legislation recently to deal with an amendment to the Explosives Act. I think that dealt with the definition of explosives. But I didn't take that one. That one, I believe, was taken by the Minister for Transportation and Works, I believe. So I don't know that I necessarily get involved with shepherding through the policy agenda because the ministers with that responsibility typically take charge of it. The areas that I would deal with that fall under my responsibility, whether by constitution or statute, that is where I would focus my attention.
See, and does this decision fall to you? Could you say, I don't think as Attorney General it's appropriate for me to pilot a particular piece of legislation through the House?
I believe it is. I mean, we don't typically have those. I mean, I haven't had a situation where it's been contentious.
Yes.
Yeah.
And you, your department would give advice across government then?
Yes, it does.
And on a day-to-day basis, that, as you've explained to the Commissioner, before something even reaches Cabinet, that you would expect that they would have, your advice of your chambers would have been sought, input at least on in terms of the legal consequences would have been obtained, and you are at least available to the House of Assembly, whether they're in government or not, to also give advice.
Yes.
This is something I'll come back to in more detail, but is your chambers, is it accountable to the House of Assembly in any way? Other than financial?
Right, so we've knocked that one off. And I'm not trying to be difficult, but what do you mean by accountable?
Do you have to answer at all to the House of Assembly for the work that your chambers do, other than budgets, which I will come back to?
The Attorney General is an independent officer, so I'm not quite sure what you mean by answer to.
All right, well,
do I have to report how many opinions I did or something? Is that what you're talking about?
Yeah, or do you have to in any way explain yourself with the work of your chambers to the House of Assembly?
I haven't had to, but there is the concept of annual reports, which would eventually make their way to the House of Assembly, typically for any department in government. Outside of that, I wouldn't say that I have to report to them or that I'm accountable to them. I'm their legal advisor. Under the Constitution, I'm an independent advisor. I don't feel constrained. I don't feel partial to them in any way. I don't know if I'm misunderstanding your question.
Yeah. Let me come back to it in a different way. I'll just deal with the third point of the triangle, which is, of course, that you're also the legal advisor to the governor.
Could I just before we move on to that, it's really actually going really back to the cabinet, but it touches upon the House of Assembly as well. Is this a fair summary of your role? But you must tell me if it's not. Your, as you say, your role is an independent one.
Yes.
But the policy agenda of the government will be determined in cabinet.
Yes.
And is it your role then in cabinet to facilitate that policy agenda by making sure that it is brought forward in a lawful way?
Right. So I want to go back to the concept of a policy agenda. And again, I'm not being difficult, but I don't know that I have seen a policy agenda.
Well, the cabinet decide that something in terms of policy is something they want to pursue. I don't mean literally a physical list,
Right.
but they have a policy that they want to pursue. That is the government, the policy of the elected government, effectively the cabinet. And I just want to try and determine what your role is initially in cabinet.
Yeah.
So that's what they want to pursue, and they'll discuss it in cabinet and perhaps change it and modify it. But is your role one of facilitating that policy and ensuring that it's pursued in a lawful manner?
Right.
Or is that not right?
And let me be careful in answering, because I think this is very important. That is what my role would be. One of my principal concerns as Attorney General is how we formulate or not, or discern what policy is. And that impinges on how well I'm able to carry out my responsibility. One of the difficulties I have as Attorney General is policies. For some reason, it's very difficult to get them created. I'm very fond of order. I may not be an orderly person, but I'm very fond of order. And one of the things that I would expect to see, not only as Attorney General, but as a citizen, is where you have a government campaigns. And my understanding, and I paid attention to this more in recent years than before, is that when a government when a government on the campaign trail creates a manifesto and makes promises and they're elected to carry out the things that are in the manifesto. What I would expect as a citizen, what I hanker for as Attorney General, is a comprehensive roadmap that comes out of that manifesto that then gets translated into the policy that any particular government, or the policies that they're going to be carrying forward over their tenure. I see considerable, I don't know that, and I could be telling tales out of school, but I'm telling you the truth. The Attorney General has not seen that sort of roadmap and policy agenda. How policy gets formulated, my only answer to that, and I'm not trying to offend any public officers who are listening, any ministers of government or anybody, but policy isn't something that's proliferating through the public service as far as I can see it. It is very difficult, even in drafting legislation. I know you want this particular piece of legislation, but why exactly do you want it? And how should it look? And why should it look that way? And what considerations do I need to take into account? Well, quite frankly, what are your drafting instructions? That's actually a real difficulty that I have. So when you speak about my role in relation to the policy agenda, and I hesitate, it's because I think that really and truly setting the policy agenda of the government, it must be difficult because I don't see that it's done very well, if at all. And that is a difficulty that I have.
That's very, very helpful. It actually answers a question, and this is not a criticism. It answers a different question, but a very, very important one, because you picked up on the word agenda. I simply meant a policy, not necessarily within the context of a roadmap or a general plan.
But my responsibility as Attorney General is to understand, in as much as I'm independent, I'm a legal practitioner, that's what we do, we be independent. But what, as Attorney General, my responsibility is to work out what the government wants to do.
Yes. No,
what it has promised to do, and to ensure that it does it lawfully, and that it's not frustrated from doing it by, you know, any other means that people may seek to employ. That's my role.
That, as I said, that's really helpful. So is your concern that expressed in your previous answer, that when you are drafting a measure, when you're drafting a bill or something, that you really need to know its full context within, this is going to mix a metaphor, but you need to know the full context within the roadmap.
Absolutely.
To be able to do your job properly.
Absolutely.
And that's a very, very important point. The question went to a different point, but I think you've answered it. And that is leaving aside agendas and the roadmap, which you've dealt with very helpfully. If the government have a particular policy, they've decided that they want to do X, then it is your role in cabinet is your role in cabinet to ensure that they do X, whatever it might be, in a lawful and proper way.
Yes.
Yes. No, thank you very much.
Thank you, Commissioner. Just to finish with the governor, obviously you are the advisor as well to the governor. Again, it's the client point. Do you just see the governor as an aspect of the government of the Virgin Islands, which is your true client?
Yes, I do.
These questions are leading to one point, which is because what can be fairly said of the Attorney General under the Constitution of the Virgin Islands is that, as we've said, you stand at the sort of centre of a triangle. And one of the points that was that you canvassed, Attorney, on the 4th of May, when you made submissions to the Commissioner, was that you recognised before the Commissioner, and I quote your words, it was you said the issue of conflict is inherent in the responsibilities given to you as Attorney General under the Constitution. And what you went on to say is that there were safeguards to protect your independence and to protect your ability to be independent. And it's quite clear from your evidence that you've given today that independence is something you cherish.
Yes.
But which particular safeguards did you have in mind?
Well, the safeguards for the Attorney General under the Constitution is her security of tenure. That is her safeguard. She has responsibilities as a legal practitioner. She's bound by the Code of Ethics. And you can't underestimate the importance of the security of tenure, because you're constantly put in, very difficult positions. You have to sit in a room and say to the ministers, you are correct. And the governor's sitting there and you say that you are wrong. All of whom I believe consider themselves to be very powerful people. And they might not like what I have to say. And sometimes, it has gotten quite frosty, because it's you can't please everybody every day. And at the end of the day, you do have to come back to what your responsibility is. And you find your solace really in the law and speaking truth to power, because that is your job.
And so the one key safeguard you would point to is security of tenure.
Yes.
If the role of the Attorney General is as you set it out, I think it is, and that is an independent role, doing some fairly difficult things and saying some fairly difficult things to, as you put it.
Every day is a difficult conversation. Yes.
Yeah, no, exactly.
Mhm.
But the role of the Attorney General, as you've cast it, and as I say, I think you've cast it very well, if I might say so, is an incredibly important one in the Constitution.
Yes.
I mean, incredibly important one in the Constitution.
It is. Yes.
Yes, thank you.
Again, returning to the difficult conversations you have to have every day, but as attorney under this Constitution, how do you deal with potential conflicts of interest, where you have on a different day you may be telling the governor you're correct and the minister you're wrong, and on a different day vice versa. But
so we should be careful with terminology, because I don't consider that a conflict of interest. That's just my job. So are you asking about how do I deal with the tensions between the people in the triangle, or how do I deal with conflicts of interest?
Let's do the tensions first, and then we'll go to conflict. So how do you deal with the tensions between the 3 points of your triangle?
Speak through to power. You don't have a choice. I mean, the issue comes up. It's not always going to favor all three parties or both parties, but my responsibility is to ensure that I give the correct advice, properly informed advice, and there's really nothing else to do.
Then move on to the potential conflict of interest point.
I'm sorry, just before we do, if that's right, which I think it is, the constitutional role is not only a fundamental one. Well, I'm afraid I can't ask this question without a slightly personal element, but the Attorney General needs to have a certain amount of strength of mind as well as independence.
Yes. Thank you very much for that compliment, Commissioner.
No, it was a compliment, but no, it was a compliment.
Right.
I actually, it seems to me that it's a necessary characteristic of the job to be able to do it properly.
It is a very necessary characteristic, and also because on a practical level, I have difficult issues to deal with. I mean, I believe that I'm possibly one of the most annoying people, for example, to the Department of Human Resources. I do not let up, because I have to do my job and I have to do it properly, and I know full well what it entails. And I've spent as much time as I can, and I'm sure I haven't done it to the fullest extent, trying to understand what the government of the Virgin Islands needs by way of legal support. And I know that I'm far from having it. And that troubles me a great deal, which is why I am as persistent as I am. And
that's a core point in your position.
Right, and that is why I am as annoying as I am, because I think it is very important to my client, given what I know about the aspirations of the people of the Virgin Islands, given what I know about the characteristics of the people of the Virgin Islands, those who have been here for a long time, those who have become people of the Virgin Islands and their dreams. You know, we have to be properly equipped to deal with the issues that face a small jurisdiction, and an aspirational jurisdiction at that. And the fact that, you know, we are, our loins are not as girded as they should be is you know, it's a very unhappy situation for me, I think. No. That's how I would put it.
Thank you very much. Yes.
So I think what we were going to move on to was the second question I put, but it was just how do you as Attorney General approach potential conflicts of interest?
Right. Very easily. We live in a small community. We know a lot of people. A lot of us are related. And I've had them come up. I moved them on to another senior attorney, principally the Solicitor General. Likewise, if she has something that she cannot touch, she would do the same thing. So you have to be very adept at recognizing it. And it's not difficult for me, and I don't know if it's difficult for other people, because I've always lived in a small community. I've always lived in a big family. You know, not because you're related to somebody, you agree with them. But you know that there are certain situations where it's not appropriate for you to be, and you distance yourself from it.
One of the matters that I've canvassed with over the last few days with a number of different ministers, and indeed former ministers, was the approach to declaring an interest in cabinet. Mm-hmm. More than one spoke about family, mm-hmm. How you can be related to a very large number of people, and that led to questions about how, you know, where they draw their line. Mm-hmm. And the Commissioner has received different answers on that. As an Attorney General, and any Attorney General in the Virgin Islands may face the same difficulty, there may be an item on a Cabinet agenda in which the Attorney General, just like another minister, has an obvious interest. In those circumstances, what can the attorney do? What's the process?
Well, what the Attorney General does is, particularly when she has read the papers ahead of Cabinet, is that she informs the Cabinet Secretary and the Chairman that she has a conflict. When the matter comes up for hearing, she's asked to leave the room.
But then who steps in to give advice to the Cabinet in the absence of the attorney?
Well, nobody stepped in when I stepped out. And that might not be, you know, that's a good question, because I stepped out in the situations where it has happened. But I believe if they do need advice, we would have to request the Solicitor General to come and deal with the matter, or in her absence, somebody else who's appointed to act in her stead.
Which is something that you could anticipate depending on the particular
Yes.
Agenda item. Now, you are obviously, you're appointed upon the advice of the Legal Services Commission.
Yes.
Going back to safeguards, do you have a view about how effective that process is as a safeguard in terms of ensuring that the Virgin Islands has an Attorney General, not just with strength of mind, but a commitment to independence?
The Judicial and Legal Services Commission is a very strong body. It's comprised of the Chief Justice of the Eastern Caribbean Supreme Court. It has a judge, could be a High Court judge or Court of Appeal, the Chairman of the Public Services Commission. I think it's a member of the Bar Association, but one person who has to be a lawyer and another person. And I think it's composed that way because you need to have a body whose normal mode of operating is to be able to identify those types of people or to interact with those types of people. You know, a Chief Justice, to get there, you would have to have some, you know, sort of independence of thinking, strength of mind. Judges, the same thing. You have to exercise that on a daily basis. Lawyers, you have to be able to see several sides of the coin. When it comes to the Judicial and Legal Services Commission, certainly as it's currently comprised, I think it's a very strong body. The process of getting to the Judicial and Legal Services Commission is where the issue is, but I don't know that I have an issue with their decision making. I just know it takes way too long for matters to get to them.
You said you have no issue with how they come to a decision.
Well, not having been in the room,
No.
right? I wouldn't know how they
Yeah.
came to the decision, but I believe that they would do it following the best principles given the composition of the persons.
But as to composition, do you think that there is, or would you accept an argument that an expanded commission would, with perhaps members drawn from the private sector, would be a helpful development?
Not necessarily, no.
And why would you say not necessarily?
I would say not necessarily because I think the composition of the body now and the persons who are represented there, there is the ability for the private sector to be represented because there's one person who doesn't need to be a lawyer, for example. So I don't have an issue with that composition, particularly if you are appointing judicial or legal officers. I think that is a good composition. And I don't know that I could think of a better one. I'm afraid I just can't.
I mean, the composition of the committee that makes the appointments is almost bound to be a mix of judges and lawyers and non-lawyers,
Right.
And it's just an assessment as to whether the mix is right, and you know,
I think the mix is right.
And you think it's right.
I think the mix is right.
Yes.
Yes.
Thank you very much.
Thank you. The other point that you've made, again in submissions to the Commissioner Attorney, and it's a legitimate one, well, that an Attorney General is seen as the guardian of the public interest. For yourself as attorney in the Virgin Islands, how does that manifest itself?
Right. So under several legislation, and that's probably the best place to look for it. Different legislation prescribed for the Attorney General responsibilities that, well, I suppose they're only prescribed to the Attorney General, so they are unique to the Attorney General. For example, to prevent vexatious litigation, or nothing else is coming to mind. I know, for example, their responsibilities under the Coroner's Act and so on.
So you can have responsibilities to intervene in certain types of cases.
Right. So most of the public interest concerns would be embodied in that legislation. For example, to be a part of the General Legal Counsel, or to, you know, matters like that. A lot of it is prescribed in the legislation. Other times, a matter of importance may come up. General public importance, you may appear amicus, or the court may want to hear your view on a particular matter. So that is typically how it is represented.
And so there will be, in terms of representing the public interest, there will be prescribed roles in statute, which sit on the shoulders of the Attorney General.
There are prescribed rules, and there are also responsibilities that you have as Attorney General. It's in your job description, for example, that would assist the public interest. Like one of my, one of the concerns that I've had and has been expressed by the public for quite some time, and which I'm hoping to be able to make some progress on, for example, is simply making the laws of the Virgin Islands accessible. You know, that's a problem because we have lots of legislation, lots of rules, but people don't always know where they are, where to find them. And even if they find them, they're not necessarily finding the correct version of something. And I'm sure you've had this difficulty. So, you know, there are issues like that given what my responsibilities are, I am the person uniquely placed to do something about it. So in areas like that as well, I would say that the public interest is what the Attorney General is there to support.
And a point you also made in submissions was that as Attorney General, you are well placed to assist the Commissioner in understanding where the public interest lies. My question isn't focused on necessarily on the Commission itself, but taking it as your experience now as Attorney General. Aside from the statutory obligations on you, your commitment perhaps to engaging with the public in terms of accessing their own laws, where else does the public interest lie for you?
I don't know if I understand the question.
It's taking, using as its jumping off point, your submission to the Commissioner that as AG, you can assist in understanding where the public interest lies. And so that prompted from me the question as well, in your view, where does it lie?
I think the question, Attorney, is in what other circumstances would you consider that your intervention into something in the public interest? In what other circumstances might that arise? You've mentioned the statutory circumstances, and the circumstances in particular claims where you might be amicus, and also in terms of the legislation, making it accessible to the public. But are there any other circumstances in which your role in promoting the public interest would arise?
The answer must be yes. I don't know, I could list them for you right now. I mean, I would benefit from some context.
That's the best I can do. I'm taking it as far as I can, I'm afraid. But it's, I think perhaps where we can agree is that it's not necessarily something that you can set boundaries to as a question, and as an issue. But would you accept this as Attorney General? It is a matter that you have to keep at the forefront of your mind.
I would accept
public
that.
Interest.
I would accept that. Yes.
Thank you. Now, we've discussed safeguards that apply to the attorney. You obviously have a Solicitor General who it's not a position under the Constitution. You also have Crown Counsel, and the Commission has heard.
You make it sound like I have a lot of people.
Well, no, we've read your position statement.
Thank you.
But the Commissioner has also heard from the Solicitor General and Principal Crown Counsel. So you have at least one Solicitor General.
You've seen the bulk of my team.
Right. Well, you have one Solicitor General and one Crown Counsel.
Two Principal Crown Counsel.
But for those lawyers, they obviously come under the umbrella of the Attorney General's chambers, but what safeguards are available to them as members of the Attorney General's chambers?
That's a good question. The safeguards that would be available to them would be, of course, the appointment and removal procedures that fall under the Constitution. And I think that's principally where it is, because they would also generally be public officers. But I think that is really within the umbrella, because their particular appointment and removal provisions fall squarely within the Constitution. Whereas for other public officers, it also falls under the Constitution, but they are in the Public Service Commission, whereas the lawyers would be under the Judicial and Legal Services Commission.
Thank you. We'll turn to, if you like, paragraph 21 of your position statement, please, Attorney.
21.
Yes. It's on page 6 that I want to take you to, but it's what you've described as your immediate priorities when taking on your office, and you've listed them there as staffing and expertise, processes and procedures, and consolidation and revision of the laws of Virgin Islands. And this is now moving on perhaps away from the role as legal advisor to government, but the other side of your job, which is to manage a chambers that has a fixed budget but has to deliver legal services across a range of entities, all of which form one part or another of government. So you are the accounting officer under your job description, responsibility for preparing your budget.
Yes.
What is the current budget allocated to the Attorney General's chambers?
I don't recall, but I can tell you it's not enough.
Yes.
Yes.
But I think as that shines clear from the position statement. But one of the
I would have to consult the budget document, but it's not a figure that's in my mind.
That's fair enough. Now the point you've made, and it starts with from paragraph 16 of your statement. That's where you address the you've described as an intractable challenge, which confronts your chambers, and that is that you are severely understaffed.
Yes.
I'm sorry. I'm sorry to interrupt, Mr. Hart. Just going back to the budget, particularly as you're the first witness to deal with general matters. Although we've heard some evidence, not very much, but some evidence about the Finance Select Committee in relation to the budget for the Registrar of Interests.
I think that's the Standing Finance Committee.
Sorry, the Standing Finance Committee. Yes. You're correct. But could you just tell us the very quite briefly the process? You are the accounting officer. You have to prepare a budget, and then do you essentially have to go to the Standing Committee, which, as I understand it, is the House, to justify the budget and answer any questions that they have? How does it work? Right.
So that is part of the process. And it's interesting you should raise that, because it's also something that perplexes me a bit. One aspect of it. What happens in practice is that the budget is prepared in my chambers. And for a reason I'm not quite sure that I understand, but this is what happens. It goes to the Deputy Governor's office. And I'm not quite sure why this happens, but apparently they can subtract. Then it goes to the Ministry of Finance, who actually prepares the budget document. And then, this isn't my strong point. Then it goes to, I think it goes to the House of Assembly the first time. And then after that, it goes into the Standing Finance Committee, where the members of the House of Assembly hear from various departments and ministries as to, well, they have to answer questions on the budget that they've presented and that they're seeking to have the House of Assembly approve. And I say there that I don't know that I'm the best person to explain the budget process. So when you have somebody else, perhaps even like the Deputy Governor.
But that is broadly the process.
Yes, broadly, who's been through it a few more times, he would be able to be more explicit on those points.
So it starts with you, it goes through the Deputy Governor's office.
Yes.
And we're hearing from the Deputy Governor later this week, I think. It then goes to the Ministry of Finance that as it were, prepares the budget. And then it goes to the House of Assembly.
But it would have to pass through cabinet first, I believe. Yes.
So Ministry of Finance prepares the budget, cabinet, House of Assembly. You think it goes to the House of Assembly, but then it goes to the Standing Finance Committee, which it comprises all the members of the House of Assembly, and ultimately it's voted on by the House of Assembly.
Yes, it is.
And others, I'm sure, will give evidence. But
yes, and they'll give lots better evidence than I have. And then after it's approved by the House of Assembly, then it has to be assented by the governor.
And again, I'm sure Mr. Rowett will come on to some details, but to put it bluntly, does your budget start at 10x and come out at the other end of something less than 10x? When you put your budget in, because you say that the budget isn't enough for your purposes, right. And we'll come on to the details of that, but as it were, how is it not enough? Why is it not enough?
So what happens is you put in your wish list, so to speak, and I imagine in arranging priorities and because the people in finance would know better than me what they project to be available. They may have to make adjustments along those lines. And that's one place where it happens, but it's also interesting to me that it happens before then as well, or that persons outside of me can say to reduce it. What I can say this year, and I have to be fair about this, is that the Minister of Finance was very accommodating, is the word I can use, and very helpful, as he seemed to have understood the points that I made about being able to provide the appropriate level and amount of legal services that the government required. This is
for 21, 22.
Yes, I still haven't been able to access the provisions that have been made, but the provision was made for me. And you're also.
Is this 2021?
2021. Yeah. Yes.
Because I know Mr. Rowett will ask some specific questions about that, but just looking at the vacant positions in your chambers.
Yes.
23 positions with regard to council is what you should have.
Yes.
And you have.
It's 9 now, I believe.
It was 7, is now 9. But
yes, but then it's going to go back down in about a few days' time to maybe 8.
But you also say that as well, that people are going. And that is, to a large extent, money-driven, is it?
To a large extent, it is money-driven. And because you're not able to entice people, you're not able to attract them, you're not able to keep them, because this is the Virgin Islands. The legal profession is very strong in the Virgin Islands, a thriving legal profession. So people have options. And it's disturbing when you can't even recruit from overseas. And that's the position that we've come to. Like I said, it's disappointing.
Yes, no. And as I say, that is clear from your position statement. Thank you very much.
But to pick up on the point that you made about the difficulty in recruitment, does it come down to effectively someone can earn more and have better support, better work-life balance, better facilities in the private sector than in public service?
Does it come down to only that?
Or is that one key aspect of it?
That is one key aspect, and until I clear that off, I don't know that I can point to anything else credibly, because I know it is a factor. If somebody says to you, I would really love to work with you, but I can't afford to work for that. That's the answers I get. You know, it's not, I don't like where your office is. I don't like the people in the office. I don't want to work hard. It's like, you're just not paying enough. And it's not, and it's a difficult position to be in. And I say this because I know that no government of the Virgin Islands has ever shied away from paying for legal services. So it boggles my mind why that money can't make it into my budget, why the positions for legal counsel in my chambers cannot be remunerated at the rates that we would be happy to pay consultants at, that we as persons who frankly should know what every person paying payroll tax in the Virgin Islands earn, why can't the government figure out what is the correct level, feasible level, even if it's, you know, not as much at which to pay counsel? It bothers me greatly. And it's not a new problem. And I know it's not a new problem because I've been practicing for quite some time. And that's always been one of the things that we've heard about. But it's an intractable problem that I cannot understand, because I'm satisfied it is not that the government of the Virgin Islands does not want to pay for legal services. I do not understand why it is why it would be acceptable or even countenanced, because the resources are there. You just need to reallocate them to the legal departments, not just the Attorney General's office. And I don't want to speak for anybody else because that gets me into trouble, but I'm not the only legal department that would be having that problem. I don't know what to say else.
No, that's very helpful in expanding on what's said in the position statement. So, Mr. Rawat.
Attorney, just you've made clear you're not the only legal department, but we obviously are aware of the Office of the DPP, but which other legal departments do you have in mind?
Well, there are also the registries where legal practitioners would have to be employed.
Can you confirm this? I mean, is there also Parliamentary Counsel?
Parliamentary Counsel are part of the Attorney General's office.
And so within the ambit of the Attorney General's office, your work will encompass Parliamentary Counsel, it will encompass Principal Crown Counsel, undertaking litigation, giving advice, and does it encompass also drafting legislation?
It does.
So all roads lead to the attorney?
All roads lead to the Attorney General's office, yes.
And you've candidly said that, I mean, but your preference would be that rather than pay consultants, money be found, and it comes from your witness statement, money be found to allow you as attorney to build a sustainable chambers.
Right. So I have no objection to spending money on consultants because sometimes they're necessary. So I don't think I quite said that. I think I said I don't understand why some of those funds can't be reallocated to chambers. And I certainly believe that you have to find the expertise that you need for any particular situation that you are dealing with. So I actually do not mind consultants. I'm actually proposing a panel of counsel where we can make sure that we identify very early on people who have particular expertise that we may be able to call on from time to time as part of what we do to complement the chambers. That's one proposal that I've made. But I do think that we need to, you get out what you put in. There's only so much that 8 people can do. And if we are serious about governance, there's that word that we use. There's really no way around it. You do need a strong, sustainable team, not just of lawyers, but of policymakers, of people who can analyze the mountains of data that comes into the government of Virgin Islands every single day. You have to ensure that the workforce, the lawyers, whoever else it is, the workforce that is there to serve the government of the Virgin Islands has to be able to do so in the most efficient and relevant way. So I'm going to hold my corner when it comes to the lawyers, but I look up throughout the service all the time because I have to get instructions. And when I get instructions, there's other information that I need. It's not always easy to get. It's not always readily available. That compromises the strength of the advice that I'm able to give. It might be accurate on the basis of what I know, but is it as strong as it would be if the other areas that were critical to the proper, efficient, and ideal is probably not the best word to use because people will say things can never be ideal, but to the best functioning of government in the circumstances, those resources have to be there as well. So I talk about the lawyers because that's my corner, and I think lawyers are important. Not everybody agrees, but they are important. You can't go very far without them. You know, you always have to check the rules. Do I have rules? Am I applying them properly? Can we take another course of action and not break the rules? These are the questions that everybody needs to be able to answer. And I cannot say it enough. It concerns me that I am not able to do more lawyering, that I'm not able to reach further down into the public service and say to people, you can come to me because I have time to listen to you. You don't have to sit on that matter for 3-4 months because you don't know what to do. You can ask a lawyer a question and they'll be available. They can guide you, they can help you, they can train people to be able to recognize things that you don't necessarily need to come to me for, but you need to be trained to understand that you must follow a particular process in a particular way, you know, without undue delay. So, you know, I talk up for the lawyers, but I'm concerned, like I said, as well about the lack of policy makers. I say policy people, people who understand how do you translate a vision into a policy, into action, into results. Those things concern me as Attorney General as well, because sometimes we end up in court. Sometimes we end up having to pay out money and settle things because we just didn't get it right internally when we needed to get it right. We didn't have the right people in the right place doing the right things. And so we end up making a mistake and it's costly. I believe that prevention is better than cure.
Or you end up with a policy which doesn't work.
Right, but then you also need, you end up with a policy that doesn't work, but you also need people who are able to pivot and to see this isn't working, time to do something else. You know, and processes and energy in place to just ensure that we can pivot when we need to pivot. Small jurisdictions, you have to be able to pivot very quickly or you will lose yourself. And that's another reality of being in a small jurisdiction, and which is why, to my mind, it is so key to have the right people in the right place doing the right things, and to make sure that all the stakeholders who are responsible for making government work can see eye to eye, can frankly sometimes get over their differences for the greater good. So, you know, like I said, I'm focused on the lawyers, but overall functionality is important to me, because if you don't have that overall functionality, it compromises my client completely, which makes, you know, my job a bit more difficult.
Yeah, thank you very much.
I should have rephrased my question in a different way, but I accept, Attorney, that there will always be a need for consultants. But the point seems to rise up from your position statement that what you believe, and with some passion, is necessary in order for you to deliver the service that you wish to deliver, is as I've always said, a sustainable team that exists over a period of time, builds up its internal expertise.
Absolutely. Yes.
So you said, and I appreciate it, that there's a bit of change there, but you have 23 positions in your department, and how many are currently filled?
I believe it's 9.
And that's your lawyers?
That's my lawyers. Sorry. I think I have 16 counsel positions, 9 lawyers. Yes. Nine
filling those.
Yeah.
Those 6. So
but overall, it's probably half of them are empty.
Right.
Yeah.
And so just to get back to where you want to your starting point, that's the first step, to fill those positions. And that involves finding a way to make them attractive to candidates, which and as you said, the first step in that is persuading people, or getting round the fact that people say, well, I'd love to work for you, but I can't afford to work for you. But if we go to paragraph, it's paragraph 20, where I'm perhaps going to suggest that's where you set out your hopes for the future, because what you seem to set out there is that what you would like the service from the Attorney General's chambers to do is not just to be a full complement of lawyers working as they are now. You want them, from my understanding of what you say there, that you want them to be policymakers that you embed within other areas of the public service. Is that right? You use the phrase to reach deep into the public service to identify and address areas requiring attention. I wondered whether one of the plans, along with your panel of external counsel that you can draw on, was whether you would like to second members of your chambers to other government departments so that they gain experience there and they are there in that department giving advice.
Right. So to answer your question, no, I don't want my lawyers to be policymakers. I want them to be lawyers. Do I think it would benefit? Because you see, this is a running conversation we have, and I don't know that I necessarily agree with the solution that comes up of having a lawyer in every ministry. I think people associate that with getting the service that they need. What I would like to see is that ministries can't tell if there's a lawyer in their ministry or not, that they get serviced when they need to, how they need to, in a responsive way. Reaching down into the public service means for me not necessarily that I take a lawyer and I put in every ministry, but I admit that the ministers, for example, and permanent secretaries and other people have lobbied me, and they've said over and over, what we need is our own lawyer, right? What the lawyers will say is, no, I don't want to do that because they want me to do everything, right? They won't just want me to be a lawyer. They want me to write every paper. They want me to prepare every policy because, lawyers are multi-talented. And I'm not saying that to be, I see some people are shaking and nodding their heads because you are very versatile. And sometimes what happens is if you have a particular level of talent or skill, then you default to it. So I'm on the fence about the lawyer in every ministry. Because I think what is most important is that the legal services are available. Not necessarily that the lawyers are available to the people in the ministries to do whatever they think a lawyer can do. if you understand the distinction
Yes.
that I'm making. But when I say reach down, I mean, we get up from where we are in Attorney General's chambers. We do outreach, we do more, I call them consultations. If you have something that's on your mind, you don't quite know what to do with it, you don't know if you should reduce it in writing, you know, come and have a consultation for half an hour or something, and then you can decide where to go with it. I feel that that would be of enormous assistance to a lot of people.
But you, as I understand your evidence, you consider that legal services should be available to all of the ministries, but having a lawyer in each ministry is only one way of doing that.
It's only one way of doing it, and I don't know that it's the best way of doing it.
Quite, yes,
Yeah.
okay, thank you very much.
One of the points you make at your paragraph 20 is that what you would like to do is and why you want to effect change. One of the reasons is to eradicate self-lawyering.
Mhm.
I wondered if you could just expand on that a little bit more for the commissioner.
That happens. If you have an Attorney General's chambers or any legal department that's not responsive, I can write that contract, just change the numbers. It looks the same every time. So the person who may say that or who says that is not a lawyer, and they believe that because the document comes back looking the same every time, it means that all the lawyer did was change the numbers, right? So I believe that these things happen, and I would like the legal services available to the government to be such a position, to be of such a standard that people don't feel the need to do that. If it's only a small contract, somebody will get back to me in a relatively, you know, short time. You know, it's not something that would frustrate what we're trying to do, you know? So that's the type of thing. These things cause problems because you would have situations, a contract comes back to you and thinking, oh, why is the contract looking like that? Would we have really done that or said that? But at that stage, you're in a full-blown case. So it's at that point, you know, the damage is done. I would prefer to prevent as much damage as possible.
And that damage is a consequence of your being understaffed. As a chamber,
partly as a consequence.
You can't give the service that you feel you should. A space is created in which self-lawyers
Self-help
emerge.
Yeah.
That means mistakes are repeated because, choose your examples, all that happens is that the numbers are changed, and to some, the importance of the AG's chambers diminishes as a source of assistance, doesn't it? And so you know, that takes you back always to the point that as an urgent need, you need to be able to find a way to bring your complement of lawyers back up to strength.
To bring it up, yes.
Now, you've also said at paragraph 23, you've listed the areas where governance in the public service would also benefit from sustained expertise, access to expertise. Now, I've taken that as meaning the expertise that you would like the public service to be able to get from the Attorney General's chambers.
Yes.
Not from the sort of ad hoc outside consultants, but that they could have access to on those areas to a sort of sustained team that would be able to give them advice.
Yes.
In order to deliver that level of service, do you envisage a need to go beyond the numbers that you have, that allowed in the chambers?
I think it's a real possibility, but of course I would be reluctant to say I need more than I'm allocated if I actually don't have what I'm allocated. And that may well be the case, but I would be grateful, frankly, to get to full complement and then be able to make that decision, because you can't just say you need for the sake of needing. You have to establish that you need them. And I believe over many years, successive attorneys general, the org chart is where the org chart is because there was a demonstrated need for it to be there, because you don't just ask for it and you get it. You sort of have to justify why it's necessary. So if I could get there and then make that assessment, that would be the best thing, because additionally, you don't know who you're going to get. So depending on what the pool looks like, depending on how you rearrange your records and the other tools and your workflows, whatever, to deal with it, you may need less people, or you might need not necessarily more lawyers, but you might need more of another skill set that keeps things moving along a bit more, because your lawyers are lawyering and somebody else is doing the other work that supports what you do. So I may well need more. I mean, one of the things you may have noticed, for example, is that the Law Reform Commission function has now been completely depleted. So that doesn't exist anymore. Well, it exists on paper, but not in people. And that is a critical function as well for, you know, a jurisdiction that aims to so far as possible remain current with, you know.
You've already mentioned it, and it's at your paragraph 25. You refer to the establishment of a panel of legal practitioners to provide drafting civil specialist legal services at published standard rates. Where would that panel be drawn from?
Wherever they can be found. And I say that because traditionally, well, I suppose it is a tradition now. In the Virgin Islands, you will have seen that the bar is very, it's very cosmopolitan, comes from all over the place. Depending on the skill sets that you want, you're not going to find them in the BVI. If you're looking for drafters, for example, you're going to look far and wide all over the Commonwealth to try to locate drafters. Wherever I can find them.
I see.
Yeah.
The second element of what you've set yourself as, if you like, your vision for all your immediate priorities was one is that it's at your 26, and it's that you're undertaking a review of business processes, record management procedures, human resources and information technology. And you say this has resulted in staff training, 3 reports assessing the status quo, mapping mission critical processes, and analyzing associated workflows, and then making recommendations. Has that review been completed, or is it ongoing?
The review has been completed. Yeah.
Can you explain some of the sort of details behind the process or the approach in terms of the review, and particularly, for example, the phrase mission critical processes?
Mm-hmm. What happens a lot, not just in the public service, but other places, there are certain things that we do, and they're all of great importance, but sometimes you're maybe assessed on certain aspects of your work more than you are on others. And what that would mean, mapping mission critical processes, is identifying those areas of work that are most popular is not the right word, that we do most and that we have to do all the time, and to make sure that we are doing those as efficiently as possible.
And you refer in that same paragraph to staff training. In terms of staff training, and I'm broadening it, not just training for your non-lawyers, but also for your lawyers. Where has the funding, or where is the funding coming from for staff training?
It came from the budget.
From your own budget?
Yes.
Are there any other sources or areas of support, financial and non-financial, that you can draw upon as Attorney General?
Not that I'm aware of, it's just the budget.
But in terms of, for example, is it open to you to work with the governor to develop or to seek to get assistance in terms of staff training? Are there sort of other law bodies that an Attorney General can draw support from?
I would believe so. The primary financing for the chambers comes from the budget. That's the reality. This year, I don't know that I've benefited from any external funding. I don't believe, if the proper procedures are followed, that there's an objection to it, because from time to time, I guess different international external bodies may offer training in different areas, but I haven't had the benefit of that this year. Everything has been done from the budget.
And so it's down to you to decide how much you can,
excuse me,
balancing priorities, how much you can allocate to staff training, because you might be taking from something else that's...
Well, not quite, because you do that in the budgeting. You know, your budget says what you're allowed to spend under each particular head. And then if you exhaust that, then you have to seek permission to reallocate funds from somewhere else to go.
Provided that the proper priority, it's properly appropriate to do so. You don't have any objection in principle to receiving support from another source. I mean, you'd obviously.
Is that a trick question?
No, it isn't. It's I hope a carefully crafted question.
No, I don't.
To make sure that you,
yeah.
Provided that there wasn't, you will be well aware of the potential for conflict. So provided that wasn't an issue, in principle, you don't as AG object to support from other sources that will help you develop or meet your priorities.
No, I absolutely do not. Of course, it is on a case-by-case basis. You would have to, determine that it would be appropriate, all circumstances considered. But no, I don't.
Just to turn to the law enforcement and justice quickly, you've listed at paragraph 30 the agencies of law enforcement and justice, and you've also, and this is at paragraph 32, you set out where your responsibilities lie.
Yes.
We've gone through some of those, but the Director of Public Prosecutions is also a constitutional position.
Yes.
What does the Attorney General have, or does the Attorney General have any role in relation to the work undertaken by the DPP?
Well, the Director of Public Prosecutions, I think you will appreciate from the Constitution, it says that she's not subject to the direction of any person. But there may be issues on which she needs to seek legal advice. There may be issues that really are not for her, but that come up in the course of what she is doing, in which case she may need to refer it to her chambers. In respect of certain issues, for example, in respect of certain issues, I've reconsidered saying that. In respect of certain issues, we may need to collaborate. There might be an exchange of ideas between professionals or something like that. But the Director of Public Prosecution works independently, not subject to anybody's direction. If we can offer advice on some aspect of her work, then of course we are available to do that.
Are there particular aspects of criminal process or quasi-criminal process that fall within the ambit of the Attorney General's chambers rather than the DPP? I'm thinking of, for example, extradition. Is that for the DPP, yes, or does it come under the root?
So extradition, it's interesting you said, because in some ways I suppose it is criminal, but I don't see it as...
It's quasi-criminal, it might be.
Right, and that it's more, to my mind, an international issue than a criminal issue where there may be, the underlying circumstances may involve criminal elements. So in a case like that, we, we may have occasion to interface with the attorney, with the Director of Public Prosecutions. But you'll appreciate, and I think the Constitution says that she's responsible for the prosecution of criminal offenses. That's how I remember it. I could be wrong. So it's not necessarily any and everything that's criminal, but rather the prosecution is how I understand her role. I'm sure she will be very firm as to what her responsibilities are. But as a matter of law, as a matter of practice, in fact, the Director of Public Prosecutions works very independently from the Attorney General's chambers.
But in terms of drafting legislation, even if it's criminal legislation, that still comes to the Attorney General's chambers. As to drafting generally, and you've spoken of having drafters in the team and wanting to recruit them to your panel. Are there, or is the practice that somebody drafting a piece of legislation can draw on model samples, if you like? I mean, if you take an example of a statute that you're asked to draft as a chambers, are there, for example, model acts that are produced by the Commonwealth Secretariat or other bodies, which you can take as your starting point and adapt, or is it sometimes that you have to start with a blank sheet of paper, which is more common?
What actually happens? I think I should say firstly what should happen, right? There's a general legislative process that should be followed when you are composing or you're drafting legislation. And it has to start with setting out the circumstances giving rise to the need for legislation. It has to do with developing the policy, right? Once that is done and you get your approval from wherever you need to get it, for example, cabinet to proceed, you're supposed to come up with very precise drafting instructions, which are then given to the Attorney General's office so that the Parliamentary Council can get on with the drafting. That is what is supposed to happen. That is the proper legislative process. In terms of using model legislation is developed regionally, for example, by the OECS, might be developed in the Commonwealth as well. But even if you're looking at model legislation, you still need to make those same decisions because of your local circumstances as to what is the policy surrounding the adoption of any particular legislation. And the legislation can't simply be adopted. It has to be complementary to the existing laws of the Virgin Islands. It has to not offend the Constitution and all the rest of it. If you're asking me if in practice we get draft legislation to look at, the answer is yes. But is that the ideal situation? No. Do I like it? I do not. Do I wish the process was followed properly? Absolutely. Do I understand that there are difficulties with following that process properly? Yes, I do. And I think that they ought to be rectified. So that is my answer to that, which I hope answers your question.
Very completely.
Thank you.
Could I just move to what's likely to be my last topic? There's a loose leaf piece of paper on the desk in front of you. If I can give this some context. On day 6 of the Commission's hearings, which was the 18th of May of this year, the Premier gave evidence, and in that, in the course of giving evidence, he referred to advice and standard advice that was given by your predecessor in relation to the waiver of the tender process for contracts over a value of $100,000. And then his attention was drawn to the document in front of you, which is a memorandum from the former Attorney General dated the 25th of October 2019. And he confirmed that that was what he was referring to. The question I wanted to ask was, firstly, are you aware of this memorandum?
I've seen it before, yes.
And I think the Premier's evidence was that this formed part of a standard pack, or it was part of the sort of information pack that would have been provided to Cabinet when they were considering a contract where possibility of waiver was on the cards.
I don't recall it from that context, but I'll take your word for it.
Well, you may have answered my next question, but it's whether this memorandum from the former Attorney General is still current, or is now a different process being adopted.
Okay, so if I may take a minute.
Of course.
Okay, so I've read it. Yes, I believe this
It's still current.
still current. Yeah.
Thank you.
When you say it's still current, and this is my recollection of the Premier's evidence, and somebody will correct me if I'm wrong, when he was asked about reasons for waiver, he said that they were cut and paste reasons, I think was his phrase. But then he said that this is what he meant. This memorandum was in the pack. So this
Well, I'm not.
this represented the reasons, he said, for waiver of the tender process.
Well, I'm not comfortable with the term cut and paste reasons, because I believe every contract must have its own justification for entering into the contract, and if the tender process is to be waived, for it to be waived. And when I say I think that the advice is still current, maybe I should be clear that the position is still and is still accepted to be that decisions made by Cabinet to waive the tender process in any given case should and ought to be supported by very strong reasons, since the default position under paragraph 172 of the regulations is the tender process. That's what when I say it's current, that is what I mean.
That's clear and helpful. Thank you.
Thank
Yes.
you.
Commissioner, may I just have one moment, please? Commissioner, those are my questions. Can I conclude by thanking the Honourable Attorney General for returning to give her evidence, but also for the very helpful way in which she has done so today? Thank you.
Could I just ask one last question, Attorney, if I may? It's actually set out in paragraph 15 of your position statement, but you also referred to it when you last gave evidence to us, that governance was a main part of your function. This is governance across government, not simply in your department. And here you say that the vision statement of your chambers is to uphold good governance and the proper and adequate administration of justice. Does that mean for good governance you need a strong and well-functioning Attorney General's chambers?
Right. So I remember that conversation that we had the last time very well. And I think at the time you challenged me as to who's responsible for good governance, whether it was myself or the governor. I believe the governor is the top of the chain when it comes to good governance. So I should be clear on that. I believe that it is critical to good governance that anybody who, or that the government simply does have access to a fully staffed and responsive legal team.
That again is a very clear and helpful answer. Thank you very much. Can I just echo Mr. Ramat's comments at the end? Thank you very much for your time. Thank you very much for your helpful and eloquent responses, and they really have been very helpful. Thank you.
Thank you, sir.
Thank you.
Mr. Ramat.
We now, I'm afraid, Commissioner, because of various scheduling issues, we'll have to have a rather longer break than we would have wanted. Our next witness, I don't think, is due until 3:30.
Good. And that is?
That's the Honourable Julian Fraser.
Mr. Fraser.
Good. If I say for the transfer, Marlon Penn, the Honourable Marlon Penn was due to come today, but has had, for personal reasons, has been rescheduled.
Good. Thank you very much. Thank you again. Yes, Mr. Rawat.
Thank you and good afternoon, Commissioner. Our next witness is the Honourable Julian Fraser. Mr. Fraser was affirmed on the last occasion, so there's no need for him to take an oath or affirm again. If I may, I'd just like to start with my questions.
Yes, thank you very much.
Mr. Fraser, thank you very much for returning to give further evidence to the Commissioner. The purpose of this afternoon is to invite to ask you questions about a position statement that you submitted to the Commissioner. As you'll remember, the Commissioner sent a number of questions on governance to a range of actors, including members of the House of Assembly, and you were good enough to provide your response to those. Your position statement has been published on the Commission's website. I'm not going to ask you to read it out or to go through it in detail. There's one short but important point that I would like to develop with you through my questions. And that is that, and it's a point that you return to more than once in your position statement. But if you turn to page 3 of that position statement, it is what you describe as a fallacy at the heart of the Constitution of 2007, and which arises from section 47(3) of the Constitution. And you dealt with this when answering a question addressed to you, which was, as a member of the House of Assembly, what role, if any, do you have in ensuring there is good governance, and how have you carried out that role? And you returned to it at your page 9, when you were answering a question, what steps do you as a member of the House of Assembly consider should be taken to promote the strengths and remedy the weaknesses you have identified so as to sustain public confidence in all elements of government? Now, what I'd like you to do, the point that you make is that, put simply, the Constitution vests a great deal of power in a Premier. And if I may, can I ask you just to develop that a little and explain to the Commissioner the basis on which you make that assertion?
Thank you, Commissioner, for the opportunity to be here today and express my thoughts verbally as I have in writing. I went to the Constitution. Actually, I went. If you look at
Do you want, if you look, Mr. Fraser, I'm sorry to interrupt you. If you look just on that top of that grey bundle, there's another bundle headed legislation and Constitution legislation bundle. If you go to that.
I could use this.
Yes, I think you set out, I think you're wanting to go to page 3 of your position statement.
Yeah, page 3.
And that's section 47(3) of the Constitution.
It says, I said that in 4.2.3, the cabinet shall have responsibility for the formulation of policy, including directing the implementation of such policies insofar as it relates to every aspect of government, except those matters for which the governor has special responsibility under section 6. And the cabinet shall be collectively responsible to the House of Assembly for such policies and their implementation. Then that's when I said this is what I consider to be a got you provision, because it says everything that needs to be said. Unfortunately, the most important part of it is devoid of reality. Still on page 3. I prefer to read it from here. Is devoid of reality. Yes, the cabinet, which essentially are the ministers, makes those policies mentioned. Yes, the cabinet, which is essentially the ministers, direct the implementation of those policies. But the fallacy is that part about cabinet, which are the ministers, shall be collectively responsible to the House of Assembly for such policies and their implementation. And I said, as far as this question, now ask yourself this question: who makes up the House of Assembly? And the answer, which is the cabinet, namely the 5 ministers and the Attorney General, and a cast of supporters, namely the junior ministers, the Deputy Speaker, and another backbencher plus the Speaker. That is a total of 11 of 15 members. So who are you kidding when you're trying to pin an unrealistic responsibility on the House of Assembly to hold the cabinet to account? You know that this is nonsense, and you didn't need to ask, or you didn't need me to tell you, but you asked, so I tell you anyway.
Just on the as it were the mathematics, which is not a strong suit of mine, Mr. Fraser, but in terms of the House of Assembly and the elected ministers. The elected ministers under the Constitution, with the amendment to the Constitution, there are 7 ministers, 5 cabinet ministers, 2 junior ministers. Right. So there are 7 ministers.
Right.
The House of Assembly, in terms of elected members, voting members, are 13.
Yes.
So the government ministers are always in a majority.
Absolutely.
Yeah. That's the point, isn't it, that you make in this paragraph?
Well, the government ministers. Okay, it's 7 because you include the junior ministers, so it's 7. They're always in a majority.
Yes.
So the point I am making is that there is no diversity in the House, no contrariety in the House, and it makes for bad policies, bad legislation. There is no need to negotiate. There's no need to come to an agreement on anything. It's only at the whims and fancy, I should say, of the Premier, if he wished to entertain the thoughts and objectivities of the other members in the House who are not part of his group. And that's a flaw. That a small democracy such as ours should try to address by remedying it. And there are remedies for it. The only question is whether or not those who are responsible for making those hard decisions are prepared to make them. And I see this commission as a vehicle for making these things happen. If I am to be correct in my interpretation of my observation and my perception of the purpose of you being here, which is to seek out the shortcomings in our system and make recommendations to fix them, then I think this is the root of the matter, the problem. It's the root of the problem.
But it's a problem, a problem as you see it, arising out of the Constitution, because the Constitution does 2 things which seem to me to be fundamental to your position statement. Firstly, it's the Premier, in effect, under the Constitution, who appoints the ministers, and there are 7 ministers out of 13 elected House of Assembly members, hence always a majority. But if that is a problem, any solution must involve changes to the Constitution. I mean, you've suggested one in your addendum, in your addendum report.
And again, that's in 2004, which was the first time I made representation regarding this issue. There was a constitutional review commission. And that was a catalyst. That commission was a catalyst for the constitutional review that we had in 2007. And by bringing forward matters like these, I hope that was what the outcome of the 2007 Constitution review was. Now, whenever this new Constitution review comes about, you just happen to be in a critical position right now to influence it. The leaps that are needed to be taken in our Constitution in order to avoid having you come back here some years from now, I don't know how many people are prepared to make those leaps. But the way I see it, I'm going to say it.
But the thrust of to pick up from the Commissioner's question, the thrust of what you said, and you find that at your page 8. And that is whether people are aware that our current system imposes legal dictatorship powers on our Premier.
Right.
And so irrespective, on your analysis under this Constitution, irrespective of party, a Premier, because the Premier selects the cabinet ministers and because the Premier selects the Speaker,
right,
there is an inbuilt majority that is accountable only to the Premier and which therefore silences the House of Assembly as a body that holds the executive to account.
Exactly.
Now, before we get on to, I'd like to canvass with you your alternative proposal, but before we get on to that, you also, and I'll take you back to page, I think it's your page 4, you also made comments about committees, and you say, if I was to elaborate on the many committees of the House, you would be equally impressed with their mandate and sorely disappointed with their powers, which are non-existent. And you then give the example of the Public Accounts Committee, which is set up according to standing orders. And you conclude in relation to the Public Accounts Committee, it needs real power if it's supposed to be meaningful. So in terms of the committees of the House, what changes would you want to see in terms of the committees of the House?
The standing orders prescribes that just about every committee except for the Public Accounts Committee and the Privileges Committee be chaired by a minister. Now, that's a basic no-no. You're not going to find that too many places that you travel. The opposition chairs committees, and also the backbenchers chair committees, not ministers. So it becomes almost impossible for a report to emerge from a committee that is not already the minister's position, the government's position. And I've said to current ministers and ministers who will serve before them, I said, if there's no other lesson that I can take away from my service, is one I gained from a senior to me at the time. He said to me, never wish for the opposition what you wouldn't wish for yourself. And I had never understood what he meant until I got into the opposition. And then I was able to see the legislature, no matter what side you sit on, as an institution. And that's the point I'm trying to get across to ministers today who don't see it because they can't. They cannot see it from where they sit. And that's what happens with the committees. It's a part of why you can't get a committee to sit right now. And not just in this government, in past governments as well. Ministers are preoccupied with their duties as a minister, and they see the world from a different perspective. And
so the value, if any, of committees is neglected because of ministers' other commitments.
I would not blame it on the ministers. I think that it's the position that they find themselves in. They could only see one side of this institution and what it's supposed to do. The other part about my problem with the committees are that when you come out of committee with a report, it's asking the same government that whose inefficiencies you have discovered to fix them. The committee has no real power to mandate that they be fixed, except that to come back to the entire body again, the same body that I spoke of, and asking them to vote in favor of having it, the committee's recommendations acted upon.
Couldn't it be said that one inevitability about such a small territory or such a small electorate is that the number of elected members is going to be relatively small? I know that you've put forward your addendum, and we'll come to that as one way around that, but where you've got as we have under the Constitution, 13 elected members, given that there's considerable burden on the government, you can expect a substantial number of ministers to be in place. The Constitution says 5 plus 2 junior ministers. And therefore, isn't that weakness inevitable?
It sure is. It sure is. But it assumes, the Constitution assumes that everyone would act in the best interest of, I shouldn't say in the best interest, I'm sure everyone is acting in the best interest of government, of the country, but in their way, the way they see it and only the way they see it. It's 13, if you got 13 members in the House, the opinion of all 13 members should matter, not just one side. And this is not a knock on this present government. It's what I see from the time I've been in, for the time I've been in the House of Assembly. And the only way you're going to get diversity is through, the only way you're going to get good policies coming out of the House of Assembly and legislation is through diversity. And that diversity has to be, it can't come from a single side. It has to be among all parties, all members. In this society, the society that we're in, I believe the best functioning government would be a coalition government in this society that we're in.
I do understand that that observation. So is your point that the current system of government, which has, you say, huge amounts of power in the Premier and in the elected ministers, and I think this is right, you'll correct me if I'm wrong because you will have the numbers, but I think in the previous administration, NDP had 11 members to 2.
Right.
And so that was, as you say, power very, very much focused in somewhere in the NDP. After the election, 9-4, power focused very much in somewhere else, and therefore that in some way results in stable policies.
Even if you take the contrast between the 11-2 that the NDP had and the 9-4 that this government has, which is now 10-3. Even as it is right now, because the Premier can't pick up the phone and call the leader of the opposition and say, let's do this, I plan on doing this, and it happens. Where the leader of the opposition now has to consult, because there's 3 parties in the opposition, or else he'll be on his own, he'll be out there by himself. I don't think he wants to be there, he wants us to work together. For us to work together in the opposition, there must be consultation. And that's the point I'm trying to make. Even that makes it better than 2 guys getting together on the phone and making a decision.
And I understand the point. Yes, thank you.
One of the other points before we leave committees you make is
well,
that...
before we leave the committees, Mr. Commissioner, if I may, you mentioned the Public Accounts Committee. The Public Accounts Committee, what I said in that regard is that I'm saying now, we need to have a Public Administration and Appropriations Committee, PAAC, which will examine public expenditures on an ongoing basis. While the PAC has an ex post responsibility, essentially examining the accounts after the fact, after the expenditures has taken place. In our case, it's probably years down the road. I think probably we have the audited accounts for 2017 or something like that.
They're outstanding, I think, yes.
Yes, sir. And if we had a Public Administration and Appropriations Committee to make sure that spending is in line with the budget, the budget.
Yes.
It'll serve better. It will serve the country better, because at the end of the year, we have money that has not been spent, project that has not been developed. Who is making sure that these things happen? There isn't a committee that for oversight in such matters.
And you make the point that the Public Accounts Committee, this House of Assembly, does not sit in public.
No.
In principle, are you in favor of all committees sitting in public?
I don't know about all. I know about the Public Accounts Committee. I am in favor of that being in public. I would say that if it's going to be public, it has to be known by all that this is what's going to happen. You can't have a public hearing tomorrow for people who has projects or whatever it is yesterday. They were not aware that this is what's going to happen. But once they become aware that this is what's going to happen, then I'm in favor of that.
And you've said that your view is that a coalition government is the best form of government for this jurisdiction. Do you, given the flaws you've identified in the committee system in the current House of Assembly, is improvements in that system, in your view, dependent upon ending up with a move towards coalition government becoming the norm?
If things remain the way they are, if the system remains the way they are, outside of the addendum that I've submitted, then yes. With the addendum that I've submitted, you don't need to have a coalition government. It's built into the system.
Your alternative proposal creates coalition as a situation that's just the permanent state of affairs.
Even if it's not a coalition, the diversity is so great, you can't avoid having discussions, negotiations, and such.
So you favor a system that effectively promotes bipartisanship, promotes consultation.
Absolutely.
Well, can we look at some of the detail of that alternative proposal, please, Mr. Fraser? What you've suggested is, and I'm going to try and summarize it, but please correct me if I get it wrong. And also, if you want to add detail, please do so. But that the Parliament of the Virgin Islands should consist of a House of Representatives and a Senate.
Right.
And that in terms of the House of Representatives, there will be 9 electoral districts as they are now.
Yes.
And so 9 representatives will be returned, 1 for each district.
Right.
But what you are proposing is a change to the at-large system.
Yes.
And which
by the way, I would prefer to see gone, but because of certain dynamics and intricacies, I think this is more palatable for people. I'll prefer to see 13 plus 4. I'll prefer to see 13 districts.
That would be your ideal.
The ideal would be just districts.
Yes.
And get rid of the at-large system.
What flaws do you see in the current at-large system?
Purpose. I haven't been able to determine the purpose, except for what it was intended to be. The only purpose I see in the at-large system is what it was intended to be, and that was to create diversity, which it didn't. And other than that, no other purpose.
What your alternative proposal is that rather than have 4 at-large seats, you will divide the islands into 3 regions. And there will be 3 representatives, 1 for each region. And then the 4th seat would be the only at-large candidate. And that person would be a full member of the House and would take on the role of Speaker.
Yes.
What you also say, I think, about these regional candidates, so that would be would that include the person slated to be the Speaker, is that none of the 4 would be associated with or a part of any political party contesting the district seats.
That is represented by any of the members contesting a district seat.
So
they can have a party of their own. The 4 of them could have a party of their own, or they could be members of any party, except they can't be members of any party that has persons contesting for those district seats.
So if you are a party leader, you have to choose. You either go for the regional seats or you go for the district seats.
Right.
And so what you would introduce is, I suppose this is your way of introducin diversity.
Yes, and that's what the at-large system was intended to be. When it was conceived that they would have 4 people running at large, they were thinking their thoughts were that these 4 people would just be totally independent of what existed, the parties that were there before, who had their members running for districts. And these 4 people will come into the House, whether they were together or they were separate, and they will have independence. What happened was that the party leaders at the time decided to, okay, get 4 people to run at large on their ticket. And it has been that way ever since. And I don't think too many people understand that that's not the way it was supposed to be.
Under your alternative system, a party, I mean, the Premier still gets selected from the membership of the House of Representatives that for which he is recommended by majority. So, under your system, would the Premier still appoint the cabinet, still appoint junior ministers?
Yes, he will.
So for someone to become a Premier, they would have to run for the district seats, wouldn't they?
Yes.
And they would have to hope. If they got all 9 district seats, then wouldn't you be back into the situation that you are now, where you have a Premier with very great powers?
That becomes a big if now.
And what makes it a big if?
The challenges will be greater. Right now, definitely you're going to have at least three groups competing. You're going to have those at large. You're going to have the opposition, the other part, two parties, 3 groups competing, as opposed to two groups competing right now. So we know for a fact that of the 4 at large that we're going to end up with, that's not part of the government's group. And it's not going to be part of the opposition's group, whoever the opposition is. It's a separate group of people in there, 4 out of 13. So we've already almost crossed the bar, 4 out of 13. How much more we need in order to keep the government in check? And besides, we got the Speaker, who's independent, as opposed to the way it is right now.
What you've said is that the regional candidates cannot be associated with a party that's putting up district candidates.
Right.
But does your system envisage how, if you assume that Party A wins the district elections, Party B gets the regional seats, would your system still allow those 2 parties to form a coalition, for example? They can
form a coalition, and like I said, with the coalition, the way the coalition is going to work is that we have to, there are trade-offs. You can't just jump right up and do it. We have to discuss it. We have to agree on it with a coalition. Because of the 9 seats, one party will have to win 5, 6, 7 seats. one party have to win 7 out of 9 seats in order to form the government. Then after they form the government with those 7 seats, they have to contend with 2 parties. The other party that won the 2 seats plus the one that won the 4 seats at large. So it's not that simple as it is. It's not that easy as it is right now to conceive of a policy, take it to cabinet, come to the House of Assembly, and just get a rubber stamp.
And how does your system deal with the problem you've identified, that committees are effectively chaired by the government?
Simple. Ministers would not be chairing any committee. Any committee, ministers would not be chairing. You got, right now we have the standing orders committees chaired by a minister. It's not the only time, it's always been the case. But emerging from the standing orders committee will definitely be a government policy, emerging from it, because it's chaired by the minister.
The other aspect of your alternative system, as I mentioned, is a Senate, which you would have a 7-member Senate with 1 president, and I think the Senate would be elected on a regional basis. So each region would elect 2 senators,
Yes,
giving you a total of 6. And the Senate president, who would both preside and be a full member of Senate,
right.
would be elected from, again, an at-large balloting. So in each case, the presiding officer of your House of Representatives and your Senate would be the one at-large candidate that would be retained under your system.
Right.
Is that right?
Right.
And in that case, in your system, in terms of dealing with legislation, can you explain to the Commissioner how the 2 houses of that Parliament would interact?
Yes. A bill could originate from either house, except for a money bill. And the bill must be passed by both houses in order to get assent. Except that if the Senate rejects a bill for some reason on 2 occasions, the House of Representatives can in fact advance that bill towards assent. So there is no, there is ample time and room for discussions, negotiations, and agreements over a bill, as opposed to what happens now. I mean, we can have bills right now, 3 readings in 1 sitting, and we can have bills with you know, comes to the House of Assembly with 0 amendments, despite what others may think. I don't see that happening under this system. And the Senate will have committees as well for oversight. And they will have joint sessions when called. Both houses are technically equal, except that the House of Representatives will be basically, the relationship will be almost basically to that of the United Kingdom. Someone has to take the lead, and it's going to come from the House of Representatives.
And in terms of the makeup of your Senate, could that come from any party?
Yes.
You wouldn't have to choose, as you would when running for House of Assembly, and there wouldn't be any. You wouldn't. It would just be all parties could run for the Senate.
Yes.
And so there wouldn't be any machinery at that level for introducing diversity in the way that you propose with the regional candidates.
No. The Senate will be just any party can field candidates. One party can win all the seats. And the purpose of the Senate is primarily to bring diversity to the electoral system.
And what you've proposed is that the House of Assembly would have a fixed term of 5 years,
Yes,
but the Senate would, the Senate's membership would not run in parallel with that, but would be on a rotating basis.
right,
So so every 2.5 years, there would be elections for half of the Senate.
right.
So the two houses of Parliament would not run parallel to each other. There would be that, and that's the way you would introduce diversity at the Senate level.
The two houses can run parallel. It's just that in the Senate, they'll have election 2 times, to the House once.
See,
Only half the Senate will have election.
and except for, I think you would keep your president for the full 5-year term.
Right.
I see. Save for the introduction of the Senate, overall, the size of your House of Assembly doesn't change.
Doesn't change.
You've still, well, you've got 13. I suppose it goes down by 1, doesn't it? Because you haven't got an appointed speaker anymore. You have an elected speaker.
Well, this person who was elected, this one that we speak of, that's why I say he's a full member of the House. He has full voting rights and all that.
But at the moment, you have 9 district candidates, 4 territorial. A speaker can be appointed, and then you have the ex officio Attorney General, which gives you your 15.
And we can also elect a speaker from within.
From within your, but what your alternative system would do would
Eliminate that
the possibility of appointing a speaker.
without
But
saying it.
do you see any benefit in widening the size of the House of Assembly?
From what it is now,
Yes.
the benefit would be for the same thing I mentioned, diversity. But just doing it just for the sake of doing it, it's not something that I would subscribe to. I would subscribe to adding 2 districts, which is Yoosvendijk and Anegada, making it 11 districts as opposed to the 9 that we have right now, and period, end it right there. But like I said, we have 4 at-large seats as it is right now, and trying to do that, trying to eliminate them would not be the easiest thing in the world to do. So we have to find a way to accommodate them.
So in terms of expansion of the House of Representatives, the furthest that you would go is going from 9 to 11 districts.
I can't justify anything other than that. I have to make a case for making Anegada and Yoosvendijk a district, which the case is easy to make, but I can't justify breaking up any other districts, and I see nothing wrong with managing the districts the way they are right now.
Thank you. May I just have a moment?
Certainly, yes.
Commissioner, those are my questions. Can I conclude firstly by thanking the Honourable Fraser for coming here and developing the points set out in his position statement, but also for the detail that he's given and the way he's given his evidence this afternoon.
No, and again, can I echo that? Thank you, Mr. Fraser. Very interesting, very helpful. Thank you for your time.
Thank you.
Good. Mr. Rowett.
We start again at 10 o'clock tomorrow.
Good. Thank you very much.